So I just want to thank first the Paralegal Association of Florida for allowing me to present to you on employment law and overview of employment law. And I want to thank Carol and Alexandra for giving me this opportunity and working with me. And a big shout out to Carol for her fantastic PowerPoint skills. She juiced up the presentation and made it beautiful and exciting. So I thank you. And if you want to gig on the side, she's your girl. So that's exciting. Okay, so I'm going to share my screen and begin with an overview of employment law and basically avoiding ethical violations in the workplace. Sounds like a mouthful. This is my bio, but Alexander gave me a great introduction. And I'm just going to add one thing to it. Being in-house counsel, I really had an opportunity to deal a lot with employment law on the back side and also on the front side. So I'm going to throw in some stories throughout this presentation that I experienced as GC in the past, over the last 18 and a half years. Okay, so Zoom meetings. I'm learning the skill, and it seems like no matter what I do, whether I tape a cat on the wall or something, Zoom meetings are definitely here to stay. And employment law is exciting too, because remote working and everything else is also really seeing a lot of discussion in the news about hybrid work, remote employees, etc. So let's get to employment law. So what is employment law? Oftentimes it's referred to as employment and labor law or labor and employment law, especially the Florida section. But basically it's kind of distinct. Labor law covers, union representation in employment and collective bargaining agreements, etc. And it's highly specialized. Today we're going to focus on employment law. And employment law is complex and constantly changing, and which you'll see through the presentation. And it really affects the employer-employer relationship and the rights of the employees and the employer's obligation to provide a safe and fair work environment free from discrimination. And the cover rights cover hiring, employment contracts, wages, classification and overtime, benefits, safety and workplace injury, leaves and accommodations, termination, retaliation, and discrimination. Basically soup to nuts from beginning to end. And what I would call it, or they've called it in talent acquisition departments, the employee's journey, right? Sources of employment law, should you want to go and look things up after this presentation, and again, if you have any questions, you can always reach out to me as well and ask me any questions, and I can direct you to your source. But basically, employment laws are federal laws, Florida state laws, exceptions, and county and municipal laws and ordinances. Now, most employment law is governed by federal laws, and I'm sure you've all heard of Civil Rights Act, ADA, FMLA, age discrimination, and all these different laws. And this is just a handful of all the laws that apply. So it really is a complicated area of law. Florida state laws also kick in, which are the Florida Civil Rights Act of '92 and the Florida Commission on Human Rights, which gets involved with the application of employment law. Florida as a whole, though, basically mirrors a lot of the federal law, and they don't have a lot of distinct laws on the books that basically go above and beyond what the federal laws provide. Some states do, and I know we all know California has a ton of laws, and it's very difficult to really follow and adhere to all those laws without really good guidance. Florida is an at-will employment state, which means you can be hired and fired with or without cause or notice, and an employee can quit without notice and without a reason. So it's kind of a mutual arrangement in that regard, but then there's other differences. There is one count, I'll get to that next. So there are exceptions to at-will, and the at-will exceptions are you can't be fired based on discrimination, based on your race, color, religion, pregnancy, national origin, age, disability, and in Florida, your marital status. Also, you can't retaliate against an employee for filing a claim, whether it be work comp, whistleblower, or any other type of complaint. There are also county and municipal laws that come into play. So like Dade County has some specific. And what's really interesting is, during COVID, the Tri-County area kind of shut down, and some of those were based on determinations made by the county, so not necessarily the state. So that's where I think a great deal more awareness was brought to these particular decisions and laws and ordinances. But times are changing in employment law. So, and there's a lot of different things that are happening and things that are slowly migrating across the country, such as ban the box movement. And I don't know if you've heard or not heard about ban the box, but it comes up in the interview process. And when when employees are making an application as a candidate to become employed. So during the interview process, and this is one of the questions, are there protections during the interview process? Well, there are. You're still protected under the specific laws we mentioned earlier during your interview process. And there's also another thing that comes into play in the interview and application process, which is a background check, whether it be credit or criminal. And that's usually governed by, well, it's not usually, it is governed by the Fair Credit Reporting Act, which is the FCRA. And it's required that you get consent from an applicant to run a background check. And these background checks are used for limited, criminal or credit inquiries. The background checks have become a big issue throughout the country, and that's where you have ban the box movement, which I mentioned on top of this slide. And that ban the box is where, there's been an outcry to prevent people from utilizing background checks in making employment determinations or to deny somebody the right to employment. Someone does something when they were a young adult and here they are later in life and, this thing pops up, or something that is not severe, but it's being used by the employer not to hire somebody. That's basically the gist behind why this ban, but one of the reasons or main reasons why the ban the box movement is big. Florida is not a ban the box state, but we do have one county in Florida that has a ban the box, actually a city that has a ban the box rule, and that would be Gainesville. So if you do have apply and a background check is run and there is something on there, the best thing to do is to give them a heads up that something might show up. Under EEOC guidelines, when an employer is looking at these background checks, they have to really evaluate how that particular blemish on a background check might, affect the relation of the position that you're applying for, how long ago it happened, and how severe it might be. In my experience, we often had people that had, marijuana convictions and they were in probation or something like that. And it could be years ago, or it could have been 2 years ago. And we really had to look at well, how does that affect their ability to do the job? Or how long ago did it happen? How serious of offense it is? And you have to take all of those things into consideration, along with your interview and managers, approval of hiring somebody and all the things that go into that particular hiring process. And each company pretty much has their own workflow for hiring, and these things get taken into consideration. But you cannot make a decision and deny somebody employment solely on their background check. And that's a critical point to remember. Also, under the FCRA, you're required to send notices to the employee, a potential candidate, that something has shown up and whether or not there's been an adverse action taken based on the background check. Also, one of the things that a lot of people overlook in the interview process is the job description. And the job description is really important because it sets the expectations for the employee and the employer, right? So it's really a mutual document and a mutual thing that people should, focus on and look at. And it also may come into play with ADA compliance in the future. If I'm talking too fast, let me know. I am from New Jersey and I am a fast talker, so just let me know. So moving into the employment process, I love this meme. We're looking for someone age 22 to 26, yet with 30 years experience. I don't know about you, but I remember early on in my career, it was like, I got hired as a lawyer for the first time, and it's like orientation first day. I'm like, oh, this is nice. And then second day, here's 20 cases, run with them. And I'm thinking, oh my gosh, do what? So I was kind of taken aback. So when I saw this slide, it just really resonated with me. So keys to an ethical work environment. Now, a lot of this is based on my experience. It's also based on a lot of research, and it's based on laws, and it's also based on psychology and different type of like SHRM and different organizations that speak to an ethical work environment. And it really is, the foundation and also of what your employee experience will be built on, but also what companies need to do. So here, adhere to the federal, state, and local laws. Well, that's obvious and that's critical, but what's else, and that of course means that do not discriminate, right? Also, it's setting accurate expectations, and that should be defined on the job description. And on a job description, there should be places where you have, your physical requirements, so it relates to ADA, and then also your actual expectations and what the job entails, and that will go into disciplinary and whether or not somebody is performing or not performing. So it really is a roadmap to what is expected of you, and it's very, very important. And I've learned that being in-house over the last 18 years. Onboarding and training properly is critical. Again, here, take these cases and run with it. And the paralegals being the literal backbone of the legal profession, we couldn't do our jobs without you. It's very important that you know what your expectations are, that you're trained properly for how that particular firm and that particular lawyer works, right? Building a healthy culture is critical. Now, over the years, I can tell you that in my 30+ year career, I can tell you that most of the cases that I had, a majority of the people complained that they were treated disrespectfully, that they weren't valued. And most of it started with not being greeted in the morning. And at first, when I first heard that, I thought that, well, like, really? But yes, really, because you're setting the tone for every associate or employee in the morning. And that disrespect, as it's perceived by them, can breed into a much deeper resentment or disdain or problems in the workforce. It affects their productivity, their attitude, the morale, and that, of course, can spread. So it's really an important factor that I have found. And I used to counsel people on, this is very critical to the employee, and especially in a multicultural work environment, because every culture has a different approach to greeting and the importance of being recognized and being addressed, respectfully, even with just a good morning, how are you doing? So I always like to stress that when I talk to people. Live your mission and values, but getting more to like the critical components, you don't discriminate. And if you have a disciplinary problem, always document it. Document, document, document. If I could tattoo that on my forehead, I would do that, because it's the only thing that the associate has to stand on and the employer has, the employee has to stand on, and the employer can stand on. And it also is kind of an agreement of the parties that each person knows what's expected of the other and what they need to do to either improve, or what the plan is down the road if they don't improve. Coaching and allowing reasonable time for improvement is critical, and not to show favoritism. Favoritism is key, because in favoritism, there's really a lot of disgruntled people come from others showing favoritism. And what I mean by that is employees really get irritated if they see Joe treated one way and Sally treated a different way. And you really get in trouble as an employer if you treat Joe one way and you treat Sally differently, and they're in protected classes, and there's opportunity, or something looks like there may be a discriminatory act or position being taken. So that's something that employers really have to be careful of. And as employees, we're cognizant of that. So that is something that is, a valid concern. Ask questions. It's always okay not to know. I think that's the most important thing in life. We always want to be learning. Be clear in setting deliverables when you're an employer, and also as an employee, make sure you know what they are. So verify that to make sure that everybody's on the same page, and it really creates a much better work environment. And if you're involved in HR, or you work with HR closely in any business, every business should have an HR person on hand or somebody they can contact, because complaints must always be taken seriously. As small as one might find it, they're critical, and it's critical to maintaining the morale of your workforce. It's critical to making sure that something isn't overlooked that could later become a much greater problem. And you should investigate complaints, and they should be confidential, they should be internal, and they should only affect the people that are involved in the actual complaint, and not broadcast across an organization, because that creates for a very sloppy and problematic environment. Also, it's important to let the person know who made the complaint what the determination is, and we must always honor confidentiality. And I bring these up because over my experience and years, I was involved in a lot of internal investigations, and I could see where something could have been circumvented and wasn't, or I could see where an investigation wasn't thorough enough and there wasn't enough information to make a determination. or the wrong determination could have been made because there wasn't enough information to really make a true conscious decision on, which way to go. So these are all important things to having an ethical work environment. Does anybody have any questions or anything they'd like to ask? If not, I'll keep moving. Okay. Rights of employees. The rights of employees are obviously governed by the federal laws and state laws, and that we discussed earlier. But most importantly, I made this list because these are the critical rights of employees that an employer is responsible for, which is to create a safe work conditions and environment, and that's governed by OSHA. And also it's and there's OSHA reportable, so if something happens, there are reporting requirements that a business has to get involved in. The right to a workplace free from discrimination, and that's any of the listed discriminations based on race, religion, sex, gender, sexual identity, in Florida, marital status. Right to workplace free from harassment, and that can be verbal, physical, or any type of, including off-color jokes. And sometimes it can be something that you see happen that isn't happening directly to you that could equate to harassment. And what's also important to realize is it's based on the perception of the person who is being harassed. Oftentimes someone might make a complaint and they'll say, well, get over it, don't be so thin-skinned. Well, you know what? In their perception, they were being harassed. And so that's where I stress the importance of investigations, because everybody's perception is different. They might take it as harassment where someone else might, let it roll off their shoulders. So that's one of the key points that I used to hone in a lot in my practice. The right to file a complaint about their work environment, coworker, or manager without repercussion or retaliation. And what that means is you don't get punished for filing it, filing a complaint, right? If there's a situation that's occurring, you have the right to file a complaint about your environment or a manager, and that should be taken seriously by the employer, and it should be investigated. You cannot be retaliated against that, or else you would have a cause of action. And retaliation can be any number of things. It can be, the lack of a promotion, or it could be a demotion, or it could be flat out firing. It could be different type of treatment. So these things all fall under retaliation. Same thing for whistleblower. I don't know if you're familiar with whistleblower, but if there's some activity that's either illegal or inappropriate activity, and you report it to a federal agency or to, basically a federal agency, and you report the particular action, they cannot retaliate against you. And there's statutes, both federal and state, that protect whistleblowers. Also, you have the right to leave or an accommodation. And the right to leave or accommodation, the leave is, from Family Medical Leave Act, and ADA would cover accommodations, but also the FMLA can also speak to accommodation, because, leave can be intermittent leave, which could also be the same, an accommodation under the ADA. So there's a lot of concurrent things and also things that overlap. That you need to be aware of, and as an employer and an employee, because you have rights to intermittent leave as well as, a week off if you qualify under FMLA. But it's not just under the laws. What's interesting, I always look to the policy of the company, because the policy of the company basically sets the framework for what rules, policies, and internal actions an employer takes or allows. So some companies have 30-day medical leave, or they have bereavement leave, or they have different leave policies. Well, if that's in their handbook and that's the policy of the company, one, it needs to be applied across the board equally, regardless of, who you are, or, your regardless, it always has to be applied equally. And then also, you can't allow it to apply to one person and not to another. Say somebody's had an immediate relative die, like a grandparent, and they get bereavement, and you can get up to 5 days, say, and they get 2 days, but the other person has, a grandmother and gets 4 days. You have to be able to justify why you make those determinations, because it should be equally applied across the board. Okay. And same with if you have a workers' compensation claim, you can't be retaliated. And of course, you have the right to overtime if you are a non-exempt employee and don't yeah, if you're a non-exempt employee. So retaliation is never good. Getting into exempt and non-exempt, and then also whether or not you're hourly employee, what you're entitled to, and a salaried employee, that's governed by the Fair Labor Standards Act and under the Department of Labor. The Fair Labor Standards Act, FLSA, is of the Department of Labor, establishes like the minimum wage that a person needs to be paid for work performed. And the federal minimum wage, which is kind of amazing, is $7.25. Now, I don't know anybody who can, live in South Florida at least on $7.25 an hour. But the Florida minimum wage currently is $11 per hour, and it is slated to go up to $15 an hour, I believe, in 2025. So there's non-exempt workers, and then there's exempt workers. The non-exempt workers basically are hourly workers, and they are entitled to 1.5 times their regular rate for hours worked over 40 in a work week. The FLSA, this is interesting. The FLSA does not govern things like regular breaks and meals, vacation pay, severance pay, sick pay. It doesn't regulate your fringe benefits. Fringe benefits fall under different laws. But in here, basically, most people think that the law basically says, well, you have to give me a break and you have to give me vacation, and they don't even address that. And that usually, people look to the state laws or local laws that determine what those requirements are. So in Florida, there's laws on the books for child labor, and there's also meals and break time laws on the state books for Florida. What's interesting is, again, these things go back to when you're looking at breaks, meals, vacation pay, the company policy is also a source to determine what these particular benefits are, how they're handled, what you're entitled to. And that's what you would use if you were going to make a claim for any one of these benefits. You would also look to your handbook and the company policy, and to make sure that, again, it's equally applied. There are exemptions under the Wage and Hour and Fair Labor Standard Act, and these exemptions are for different types of employees that are either executive, administrative, or professional. There's computer exemptions and different type of classifications of employees. Even farm workers are classified differently. And based on these classifications determines whether or not you're entitled to overtime. You can go to dol.gov for extensive descriptions about these, but I'm just going to give you a little bit of an overview. So we all know that when you work overtime, you want to be paid overtime, unless of course you fall on one of those exemptions. So determining classification under the FLSA, it's an interesting time right now with FLSA and classifications, because there's a new, the Code of Federal Regulations was amended, and changes go into effect March 11th, 2024. And this basically is rescinding the prior rule that was made by the prior administration. As administrations change, rules often change as well. And so in this regard, there's protections that employees have under the FLSA, as we already discussed. And once you but first you have to determine if somebody is an employee or if they're an independent contractor. So this new rule basically looks to that determination to determine whether or not first you should be treated as an employee, and then you would determine whether you're exempt or non-exempt, or if you're an independent contractor, which basically means you work for yourself, like Uber drivers, gig workers, freelance operators. Previously, they've all rolled up into independent contractors if they met that test. And so here in the presentation, there's a link for you to look and just read a little bit further about this particular area. But under the new rule change, which goes into effect in March 11th, there's a new economic equality test, and it has multiple factors, as you can see. Before, it used to be like a 5-factor control test. Now it has all of this criteria to determine whether or not, in fact, you can be qualified as an independent contractor. If this criteria is not met, then you have to, basically, they're going to say you should be reclassified as an employee. Now, mind you, this hasn't been tested yet. It hasn't rolled out yet. And I'm pretty sure that we're going to see litigation and a lot of different changes, or we will have a lot of employers maybe reclassifying employees if they haven't done so already. I would caution them to do a complete audit and make sure that everybody is, classified properly. During COVID, there were times where, especially when software development companies, there was a great demand for coders and programmers who normally may or may not fall on the exempt side of the equation when it comes to how you classify somebody. But there were a lot of different people that were hiring people from outside of the country as contractors. And so with this new rule, it's going to make it a little bit more difficult for people to be classified as an independent contractor versus an employee. And of course, why would you want to classify somebody as an independent contractor? Well, because you're not carrying them on the books. They're responsible for their own taxes. You don't provide them benefits. They're not entitled to overtime. So there's a lot of different reasons why. But then on the other side, you want to be a contractor because it's like gig workers, it gives them the freedom to do what they want to do, work when they want to work, operate how they want to operate, and things of that nature. So there's there's a minus and plus on each side. One of the big things here is this profit or loss depending on managerial skill, and that's going to be interesting. Their ability to have a profit or loss based on your skill. So more will be revealed with this new economic equality test. So it'll be interesting to see how this rolls out and then what type of litigation comes from it. And again, the gig economy is very critical. You'd be surprised what large percentage of workers are engaged in gig economy. There's people that are full-time workers, but they're also giggers on the side. So it's really interesting. So again, we'll see how this plays out. So. Now determining if an employee is exempt or non-exempt. I think I'm doing well on time. Is there anybody who has any questions in between, or I can hold them to the end?
Brenda, I'm sure the people on this Zoom is going to want to know where paralegals fall, exempt, non-exempt. So if you can tie that in.
I was intending to, because I know we talked about that earlier. Okay, so determining if an employee is exempt or non-exempt employee. So there's basic tests out there that determine whether or not where you fall within this realm of classification. So the executive exemption basically is just like your president of the company or executives that basically provide the primary duties of managing the enterprise, the department, et cetera. They manage people, they can hire and fire and things of that nature. And I always looked like your CFO, your president, and people like that. The administrative exemption is where a lot of people fall that may or may not be qualified to or necessarily classified correctly. And in the past, I believe paralegals often were put into the administrative exemptions. So in the administrative exemption, basically what is new recently, they changed the salary requirement, which is the basis salary that is required in order for you to even be an exempt employee. And that used to be $455 a week. It's now increased to $684 per week. And that equates to $35,568 a year. And I believe most paralegals should be making more than that. So also your primary duty has to be non-clerical. Must be clerical, non-manual work directly related to management or general business operations of an employer and customer. And you have to it requires that you use exercise of discretion and independent judgment with respect to matters of significance. Now, I think in the past, this is where the issue was around paralegals. Years ago, paralegals were paid, they were treated as exempt and they were paid a salary. And we all know they work a lot of overtime. Or more often than not, they work overtime. Department of Labor issued rules or letters basically determining whether or not paralegals were classified as exempt or should be, and it was determined that they were non-exempt employees. And I can get you the Department of Labor letter, I believe. I don't have it here, but I could provide it to you later. But it was determined that paralegals did not meet the test in order to be declared exempt employees, and therefore they were non-exempt and they should be paid overtime. Now, what's interesting about when you get somebody who is non-exempt and entitled to overtime, there's other types of laws and applications that come into play when you're dealing with calculating that overtime, things like a fluctuating work week and things of that nature. But for the most part, for the purpose of this presentation, if you're entitled to overtime, then it should be paid at time and a half. So when most paralegals, and unless you have a different type of job description, and again, another reason why job descriptions are so important, would be declared non-exempt, which means you're entitled to overtime. And again, this is something that has changed over the years, but I know for the last, I don't know, 5+ years, maybe 10+ years, paralegals should be declared non-exempt. It doesn't mean that you can't be paid a salary for your work, but you're also entitled above and beyond that salary. You're entitled because the salary is for the 40 hours of working per week if you're full-time and part-time, whatever it's 30 or under, or whatever you're being 32 and under. So the 40-hour work week is, you encapsulate that with your salary, and then anything over and above that would be you'd be entitled to overtime pay. Professional exemption, you still have to meet the salary of $684 per week. And then there's different types of professional exemptions, and I'll just go over this briefly, which is your learned professionals, and that's if you have an advanced degree like lawyers, CPAs, engineers, things like that with that. Yeah, and it also includes work requiring consistent exercise of discretion and judgment. Advanced knowledge of a field of science or learning. Advanced knowledge must be customarily acquired or prolonged course of specialized intellectual instruction. So it just means you had to go to school. And I know paralegals go to school for a long period of time as well. But this particular learned professional has always spoken to like lawyers and doctors and things of that nature. Creative professionals also have to meet the salary test, and they have to perform work that's like innovative, imaginative, originality, or talent, and things of that nature, like screenwriters. However, copywriters are more often than not exempt, and a lot of companies do have copywriters as exempt, or editors. These particular positions have to be looked at based on the job description and the actual work done, not just what's on the piece of paper, because the title doesn't matter, all that doesn't matter. You have to actually look at the actual work done and what their primary duties are. Same thing for computer employee exemption. That gets very complicated because help desk people are treated one way, but a programmer and developer might be exempt, where a help desk or a networking person would not be. So all of these things require a good detailed job description and a good evaluation as to what exactly that particular position is performing in order to be able to figure out what they should be paid. The computer area and the paralegal areas have been big areas where rulings have come down for that particular reason, because they were not accurately either assessed or classified properly. These are some other outside sales exemptions, like people that do retail sales. Oftentimes they're exempt, but there's a very complicated rule that goes behind that. And if you are really ambitious, you can look it up. It's very complicated. And there were some not recent, but there are some 2 good cases that really define the outside sales exemption and your retail exemptions. And I was involved in retail, so I had to spend a lot of time in those cases, as well as the actual rule for the FLSA rule. Highly compensated employees, if you made in 2023 $150,000 or more, you're considered a highly compensated employee and exempt. And then it goes to police, firefighters, blue collar workers, etc. And you can go to the DOL and you can look at the fact sheets. I recommend the fact sheets if you have any questions. They're awesome. They're very detailed and they're very succinct. So you don't have to read this like 100-page regulation in order to understand what's going on. You can just go right to the fact sheets. There is some safe harbor, and when there is a reclassification that occurs. Now, the safe harbor gives the employer the opportunity, if they have to reclassify, say they paid a deduction improperly, or the pay was inadvertently incorrect. As long as they were acting in good faith and it wasn't intentional, they can always go back under a safe harbor rule and recalculate the potential rate in overtime or straight pay due and pay it at correct rates. They can also make, like what I I actually had this experience in my practice where a group of workers was inappropriately classified. So we went back and we looked, we went 3 years, but there's a 2-year safe harbor in some circumstances. And we went back and we verified the hours worked when you can track it. Because oftentimes if somebody is salary and they really should be, or they're salary exempt and they should be, hourly, then you have to figure out how are you going to calculate those hours, right? That's why it's always important to document your hours worked, whether you're salary or hourly. And that's because if, God forbid, you have to go back and reclassify somebody, or you get audited by the Department of Labor, you always want to make sure that you have this information to go back and make the reclassification and make it correctly, make sure that you're in compliance. And also if you got audited, God forbid, you had that information. You also have to notify the employee that you're making a reclassification, and you have to communicate the policy to prevent future errors. And you also have to advise them that if they want to make a complaint about it based on FLSA, they can make the complaint and to what agency to make it. And you always have to pay the back due wages. You don't want to get involved in a litigation with this merely for the sole purpose that, the employee only gets what they're due. The lawyers usually get, a great deal of hourly fees and costs, and the employee again gets what's due. So if you think you're being inappropriately paid, or if you weren't paid properly, or they took a deduction for, say, a uniform or for something that or a work tool, and that brought you below the minimum wage of $11, say in the state of Florida, then you are due wages to bring you up at least the minimum wage. And that's one of the complaints that you see a lot in FLSA cases. What I suggest to people and employers or managers and even yourselves, verify the schedule and hours that you're working, confirm in writing, amend a job description, and just make sure things are, communicated to the manager as well as to the employee. And if you're the employee and you have issues with it, take it to your manager, get your questions answered, because it's important. Also verify, yearly increases in your systems. Like if you also manage payroll, you want to make sure that your payroll records are up to speed, and also that if there's been an increase in a minimum wage and it applies to your associates and your employees, then you definitely want to make sure you do that. It's always best to be proactive and not get involved in proactive with compliance audits, but you don't want to get involved in a DOL labor audit. They're never fun. So discrimination, ADA, noncompliance, and retaliation. So this kind of ties up all the different sides that we've gone through, right? So an employer cannot engage in any type of discriminatory employment practice, and that includes, whether it's race, religion, national origin, color, genetic information, pregnancy, sexual orientation, childbirth, identity, and age, which is over 40. Most people don't know what age that begins at. Disability, retaliation, intimidation, genetic information. And then of course, Florida's marital status. Well, you can't, like, domestic partner or, married or etc. So an employer cannot do those things. And so if you have any questions about that, if you wonder whether or not you've been discriminated against, I would always direct people to the EEOC. They have great sources of information. And if you have questions that you want answered, you can always look to the EEOC. They're just really a wealth of information. They give a lot of free seminars. If this topic really excites you, you can go on the EEOC website and just, learn as much as you possibly want to. As far as employment actions that can be challenged as discriminatory, and these are the ones that you'd file a complaint, you would file it with the, Human Rights Commission, you file it with the EEOC, and that includes discharge, whether it's firing, layoff, hiring, promotions, things of that, harassment, pay, failure to provide an accommodation for pregnancy or under the FMLA based on a medical condition, exposing your genetic information. Say you have a disease like multiple sclerosis and they expose that information to fellow employees or to your manager, that's inappropriate. Or any type of retaliation for any type of action. Again, you can always go to the website at usa.gov for job discrimination and harassment, and you can look that stuff up. So that basically wraps up our employment presentation. I hope it was informative. I hope that it made you think and that you got the information that you were looking for. If you have any questions, this is my contact information. If you have employment cases and you'd love to use me as a mediator, that would be great. But if you have any questions too, or if you're looking for sources or anything like that, that you want more information, just shoot me an email or call me. My cell and our office numbers are on here. And you made it through employment law. Good job. And I always add in there, when in doubt, call HR or contact HR, because that will circumvent a lot of problems. And with that, I'm going to stop sharing.
Thank you, Brenda. That was very informative. People have been asking me via direct message if they could have your presentation, which I believe you said that was okay.
Yes.
They can resources. So I'll share that when I send out the certificates of attendance. One thing, because I know this has been an issue with people working from home, someone direct messaged me that they're taking care of a family member. In terms of the non-exempt, everything still applies, right? Because there seems to be this expectation, because you're not physically coming into the office, it's okay to work an extra hour or be more available to your attorney because they're giving you this flexibility to work from home. So if you could kind of clear up that little
Wow.
that people have. Yeah.
Talk about muddy waters. That's really been a big issue. I think across the board, no matter where you work, is whether, a lot of times people think, well, I'm giving you all this flexibility, one, that you should be on call more. And the reality is if your job is a 40-hour-a-week job, it's a 40-hour-a-week job. If there's overtime, you need to be compensated for overtime. There's no working above and beyond and not getting paid for it. Anything that would apply to your office inside, like if you're reporting to an office, should be the same in your home office. I do know that a lot of people do work more, especially salaried associates, often not especially, but some salary associates, the first thing they do is sign on in the morning because they don't have a commute, they don't have this, they don't have that, and they find themselves really working much longer hours. And you all might find yourselves doing the same thing, but the reality is if your job is for 40 hours, that's the 40 hours and you should be compensated above and beyond. As far as taking care of family members, that's why I always stress communication. Oftentimes people are afraid to ask their boss or ask the person that they report to for some type of accommodation, whether it be through, ADA or whether FMLA or whatever. But, approach that conversation. Or if you have an HR department, go to the HR department and let them know what your issue is. I have to take care of my mother. I have to take her to a doctor appointment. I'm not available from 11 to 1, but I'll make those hours up. Now, making those hours up is different than, it still should be done within the 40-hour framework, right? If that's what you're hired for, or 45 hours, however many hours. So your employer should be able to work with you. And now not all do. Some want everybody to go back to the office. And unfortunately, that's going to force people to make decisions, right? Because for the last 4 years, you've had that flexibility, throwing in a load of laundry here. But as long as you're getting your work done, and there's been a huge push for management to change from that regimented management approach to a more flexible management approach, where if your work is getting done and things are being timely delivered, then you should be afforded the flexibility you want, because you're adults, right? We're not kindergartners, we're adults. You should be treated like adults, and again, with respect, knowing that you're doing the work that is expected of you, right? Again, it takes me back to the job description and then the discussions of what are the deliverables and when are they due, because it's not just what do I have to do, when do you want it by? Lots of times I want it in a month, and then you have 10 days, and then 2 days later they're saying, where's that presentation? And you're like, wait a minute, you said it was due in 10 days. So your employers have to give you reasonable expectations and delivery dates and deliverables, and you have to meet those. But if they're being unrealistic, then that's a conversation you have to have. I hope that answered your question.
It did. And I think that there's also a responsibility of the paralegal, because if you have that flexibility and you work 40 hours, yeah, you might have a different schedule, but you need to be the one to advocate for yourself to say,
Yeah.
I'm being over abused a bit,
Yes.
and kind of set those parameters. I personally like flexibility. I come in really late. I work later, but I know that I'm still working in the time frame that I'm supposed to for my firm. I have a question. Are there minimum sizes where small boutique employers are exempt, like 15 or more employees or Civil Rights Act to apply? I guess it
Yeah,
does.
there are, yes, there are, and I would direct you to the laws. Basically, it's you have to have a certain number of employees for certain laws to apply, and it varies whether it's the ADA or FMLA and things of that nature. And even with FMLA, you have to work, I think it's 1,220 hours. Yeah, before that you become eligible for it. So there's different things like that. There's all different nuances to each law. So you could always find that information on the websites for the particular law. Go onto the Department of Labor, or you can go to us.gov and look at that information. But they do fluctuate depending upon the size of the office. But I liked what you said, Carol. I think it's really important that people feel free to have those conversations with with their boss or whomever they work with or for, because I think it's important that everybody has the mutual understanding as to what's expected. And if you really feel like you're being abused, you have to make that complaint. And again, what's interesting is employees have to make complaints. The best thing is you make the complaint before you act on it in a more direct way, like filing an EEOC complaint or something like that. The best bet is to have a record for that. So you really have to go to HR or go to your boss and make the complaint and then follow it up in writing and just say, we had this discussion. And that way everybody's on the same page. And it really is just respectful for both of you. You both know what's going on and what is expected of the other. And I think that makes for the best ethical and happy workplace, right? I've been in jobs where, I never knew what the expectations were. So you're always working 70 hours a week and you're going crazy, and you're just feeling like I could never figure out or ever get to where I wanted to go as far as having a completed task, So I think it's important that everybody respects one another and does that.
That's great advice.
That helps.
For the paralegals on the call that want to make those complaints but are afraid of retaliation, how would you suggest they approach HR in a way that is going to not make them seem like a complainer? We think of Florida as this at-will state that I could be fired for anything. So what happens when I go in this day and then 2 weeks later they're telling me I'm fired for some other reason? Is there a...
Well, I'm not going to say that couldn't happen, because it does
Right.
happen. However, it's not right? So if you're a paralegal and you have a complaint, what I would recommend is you do in fact go to your HR department if you have an HR department, or to your manager. And I think what you need to do is make sure that you frame it properly. And what I mean by that is make sure you're pointing not like feelings and all this. Go in and say, this happened, I was paid, I worked X number of hours and this happened. Or if an event happened, make sure that you frame it with facts and you take it to the HR department and you make an appropriate complaint with them, but in writing. And if there's any type of retaliatory action, then you need to bring that to their attention and say, hey, I feel like I'm being retaliated against because I made this complaint, and that's not appropriate. And I think something needs to be done. Either I need to be transferred to another person, or I need, some action needs to be taken, right? If you feel that they're not doing that, then you would step it up and make a formal complaint where you could file with the EEOC or whatever avenue it is, depending upon the complaint, right? But I do believe that you first have to make them aware of it. Now, there's always a fear of repercussion or retaliation, but under the law, you're protected and it shouldn't happen. I'm not going to sit here and say it doesn't happen, especially in smaller businesses, because they don't necessarily have the awareness. But yeah, I'm not going to say it. I just think that you have to address it in a professional manner, and you're not being accusatory. You're basically just saying this is what happened and it's inappropriate and I need your help. But if they're smart, they won't fire you for making that complaint.
Hope that would be the goal, right? The hope.
Always the goal.
Does anyone have any other questions? I know a lot of people have been asking for a copy of the presentation, which we are going to provide, telling you how informative and excellent and the great.
Oh, good.
So if anyone does labor and employment, I know a couple of people emailed me that they do. please consider Brenda for your mediator because she has decades of experience and knows all about this, as you could tell. I am going to ask everyone to turn on their camera because we do a little group shot at the end. If you have a camera, I know not everyone has a camera, and that's okay. 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 I'll give everyone a minute to do that. Okay, and let me go over here. All right, everyone's coming in. Okay, so everyone look in the camera and give me a big smile. Thank you. And I'm gonna do one more. You should get your certificate of attendance in the next 5 days. Also, we are going to have, you heard about the membership drive from May 22nd through April 22nd. We are having a membership drive happy hour in Broward at the quarter deck on University between 595 and Griffin. It's free to all members. If you have a friend, bring the friend over. We would love to see our chapter grow and love seeing you guys every month. We do have 2 raffle prizes to give away today. And the way I do it is I ask the sponsor to give me a number between 1 and the number of participants we have. Mediation Works picked number 16. And our winner is Denise Ingleton. I know she was on the call before. I saw her a little while ago. So congratulations, Denise. If Joanne is still on the call, just give us a few words about Mediation Works, if you would.
Hi, good afternoon, everybody. Thank you for attending. And Brenda, excellent presentation. And I think you've given everyone a lot of food for thought with this. And so thank you again for that. And we're thrilled to have Brenda on our team. As Brenda said, you guys definitely are the backbone of the legal community, men and women alike in your role. So thank you for all that you do. And at Mediation Works, I'm one of the co-owners. We've been in business for about 7.5 years, going on our 8th year. And we know that you have a choice in deciding who you want to use as your mediation company. We hope that you'll think of us. We like to consider ourselves a white glove type of service to you, and anything you need, we try to accommodate as best as we can. So we have 8 mediators. We obviously do mediations ranging from the employment and wage and hour, as Brenda does, along with insurance claims, PI and wrongful death. We have Spanish-speaking mediators should you need. We will do arbitrations as well as mediations. Some of our mediators will do things in person should you need. So again, we'll try to accommodate. Brenda, Brenda's raising her hand. She'll do in person. So again, anything that we can do for you, we appreciate all of you and are very proud to be a sponsor.
Thank you so much, Joanne.
Thank you.
And then the second prize is from my firm. We do catastrophic personal injury. I hope I never have to help anyone on this call. But if you have a client or if you work at a firm that does PI but doesn't do medical malpractice or products liability, you could reach out to me. We're giving out a Visa gift card, some company merch, and some other goodies. And the winner is, I had Alex give me the number, so it's not, it wasn't fixed in any way, is Wendy O'Brien. Wendy, are you still on the call? I think she is. Let me check. Sometimes people don't have the cameras, but yes, you're here. So Wendy, I'll send you an email. Congratulations. Hopefully we'll see you guys on at our next CLE next month, which we'll be sending out an email blast on, and at our happy hour for our membership drive. If you're not a member of PAF, I think we might have a couple on today. We'd encourage you to join. Tell your friends. We have a nice little group going. We have events planned and some volunteer things coming up. So we hope to see you again soon. Thank you so much for joining us, and we'll see you next month. Bye, everyone.
Thank you again. Appreciate it.
Thank you so much, Brenda. You're fantastic.
Thank you.
Thank
Thanks,
you.
Alex.
Have a great rest of the week, everybody.
Bye,
You
Bye,
too.
everyone. Bye, Joanne. Bye, Ricky.